This is Bonnie Vandermeulen, Training Coordinator for Wisconsin Facets. On behalf of our entire Wisconsin Facet staff, I'd like to thank you for joining us today. Today's webinar is entitled Special Education Legal Updates, and our presenter for today's webinar is Paul Sherman. Paul has been a school administration consultant on the Department of Public Instruction Special Education team since 2007. At the department, his work includes complaint investigation, procedural compliance monitoring, and providing technical assistance to parents and public schools. Paul holds an undergraduate degree and a law degree from the University of Wisconsin at Madison. It gives me great pleasure today to introduce to you Paul Sherman. Paul?
Thank you, Bonnie, and thank you to Facets for inviting me to participate in today's webinar. I'm glad that we have a nice large group of people, and I'm also thankful to all of you participants for spending your lunch hour with us today to learn about some special education legal updates. Basically, we're going to look at kind of three different things today. I'm going to share with you some recent IDEA complaint decisions and results that we've had over the last year or so. I'll also give you a brief update on some administrative rules changes that are in the hopper and some which have now gone into effect. And then I'd like to wrap things up at the end of our conversation today by talking about a topic I think which is becoming more prevalent out there, and that's the issue of face coverings and how it affects our students who have disabilities and underlying health conditions, and sort of how it fits in with mask mandates and the like. Before I step into our discussion about complaint decisions, I think it's probably a good point here to talk a little bit about dispute resolution options for IDEA issues. Maybe some things we can do to prevent them from becoming complaints that we here at the Department of Public Instruction need to investigate and issue decisions on. First of all, I think many of you probably know this, but the department likes to remind people whenever we can that an IEP is not a document that's set in stone. And any problems with an IEP can always be corrected through a subsequent IEP team meeting. So if the school district or the parents have a particular concern about an IEP not working, not providing what a particular student needs in order to be successful in school, one of the first things we always think about is, well, let's have an IEP meeting and talk about those issues. There's no need to wait for a whole year until the next annual IEP is due to address those issues. And as parents, you always have the right to request an IEP team meeting, and the district should grant your request to have that meeting unless it's clearly unreasonable to do so. And that's a pretty high standard. So parents can be quite confident that if they ask to have an IEP team meeting, they're going to be able to have that opportunity to have the team get together and discuss whatever particular concerns they have. Another thing I always recommend is that parents contact the Director of Special Education for their school district if they've got any concerns about the IEP. Oftentimes the Director of Special Education can resolve those concerns, either through the IEP process or outside the IEP process if it's something that doesn't necessarily need to be addressed through a meeting. I'm often kind of surprised when parents call here to the department that they don't know that their district has a special administrator who's designated to make sure that the district is complying with the IDEA requirements and state special education law requirements, and that person is known as the Director of Special Education. If you go to the DPI website and you just type directories into our search box, you'll get a page that comes up, and there is a specific directory for special education leadership personnel, and you can find out who the Director of Special Education is for your district and what their contact information is. Of course, beyond those methods, we do have a very robust system in Wisconsin of idea facilitation and mediation, where we can get neutral third parties involved in the IEP team meeting process to try to make sure that the meeting goes smoothly and that everybody's concerns are heard. Or if there's a particular issue that just can't seem to get solved, mediation offers an opportunity to have a different route towards doing that. So again, if you go to the DPI website, the special education team, and just type in mediation, you will find information on how to request those services. And they're free and they're voluntary. They're no cost to you or the district, and they're available for you to use. If that can't resolve the situation, then we are in a situation where it might be appropriate to file a state special education complaint. Again, you can find information on how to do that on the special education team webpage. Just type in complaints or dispute resolution, and you will find that we have a form there available for that purpose. Once we receive a complaint here at the department, we acknowledge it with the issues we're going to investigate, and then we have 60 days in which to conduct an investigation and issue a final decision on the complaint. So I'm sure that's as familiar to many of you, but I wanted to make sure that we kind of started there, and now we can move forward and start looking at some of these recent complaint decisions that I thought might be of interest to you and what's going on generally out there in the world right now. All right, the first sort of group of complaints that I would like to talk about are complaints that have been related to the ongoing pandemic and the COVID-19 circumstances that have been involved. Unfortunately, this has gone on much longer, I think, than any of us could have predicted that it would. It has had many different effects on students with disabilities, students who have IEPs, and we've issued quite a few decisions now on how this has all been interacting with state and federal special education law. The first case I'd like to start with is 20064. Okay, as you recall, all states were closed by a public health order on March 18th of 2020, and they remain closed through June 30th, 2020. After that period, the schools were not closed by a statewide public health order. They were either closed because there was a local health order in place, or because of a local school board determination as to how the school would operate. And it's important to keep those two periods of time in mind because they're treated a little bit differently in terms of what our expectations were and what the legal expectations were for what districts would be providing for students. So in this particular case, the events relevant to the case took place after that initial period when schools were closed by a statewide order. And in this case, the question was a reevaluation. And what had happened was that the district even though we were in this period where schools were no longer closed, the district was saying they were not willing to conduct the reevaluation until the district resumed face-to-face instruction. Okay. We concluded that was not appropriate. The district had to proceed with the reevaluation, even though the district wasn't offering in-person instruction. The district needed to consult with local health authorities and follow all health and safety protocols, but they needed to figure out how they were going to complete the evaluations for which there had been referrals and consent during that period. And that may be that there was a need to do some type of virtual evaluation or, if necessary, in-person evaluation. If the student was unable to access virtual instruction due to their disability-related needs, then the IEP team had to determine how to provide in-person instruction in order for the student to receive a free appropriate public education. So sort of the exigencies of COVID-19 and whether schools were doing virtual, hybrid, in-person instruction, whether the schools had to be closed temporarily as a result of local issues with COVID transmission, the district still has a general obligation to complete their child find obligations, to do evaluations in a timely manner, and make sure that the student is receiving FAPE. And it's just not sufficient to say, well, we're all on virtual, and if that doesn't work for a particular student, that's just too bad for that particular student. No, there needs to be FAPE provided, and it's up to the IEP team to determine how to provide that. Okay. Complaint 20054. Here, the school district was operating in a hybrid mode for the 2020-21 school year based on local school board decisions. And the student in this particular case had demonstrated that virtual environment that was not working for them. In fact, they had in summer school prior to the start of the 2021 school year, had been in a virtual environment for their summer instruction and were not being successful in that situation. Right? Here, the parent recognized that and said, based on that past experience and what's been going on here at the beginning of the school year, I think my child needs some additional in-person services in order to be provided FAPE. And the district has to, and our decision in this case was that the district needs to properly respond to that type of request. Yes, there are COVID concerns at the moment, but just like any other parent concern, request for discussion about an IEP meeting the student's needs, the district needs to respond to that appropriately. And in responding to that appropriately means that there is an IEPT meeting held and that there's a thorough discussion of the student's needs and documentation of the parent's concerns. If the district is going to deny that request, then the parents need to be provided a prior written notice setting out why they're not going to comply with the request. Okay. 20055. IEP teams need to determine a student's need for in-person services based on a team discussion of their unique disability-related needs and cannot be based on a predetermined schedule. Okay. So in this case, go ahead.
Paul, if I can interrupt, please. We do have a question on the section that you were just talking about.
Okay.
And the question is, how do you provide prior written notice for parental in-person services before having an IEP?
Oh, right. There are two kind of questions there, right? One is if the district was refusing to hold the IEPT meeting, the expectation would be that they would issue a prior written notice setting out the reasons they were refusing to hold the IEPT meeting to discuss those issues. And this is a little bit confusing and not just to parents, but to everybody. The IEP document itself is also a type of prior written notice. So if you have the IEPT meeting and you discuss the issue of the parent's request and you document the parent's concerns and request within the IEP document itself, and then the IEP document itself, sets out the district's reasons for choosing a different path forward, that IEP itself can also be considered prior written notice. So generally the prior part is kind of the confusing sometimes. That's when a district just is not going to respond to your request for a meeting. The the documentation of what actually happens at the meeting can also be the prior written notice. So,
Okay, thank you for that.
yep. Okay, back to 20055, right? Here, the complainant and the district staff exchanged emails agreeing to update the student's IEP to include virtual learning. However, rather than describing the circumstances under which the services were intended to be provided in person and when they would be provided virtually, the IEP was universally updated to remote learning for each service. This update gave the impression that the student was to receive all services virtually, while the placement page stated that the IEP would be implemented at the school the student would attend. In addition, the description of the student supplementary aids and services revised in a manner making the district's commitments of resources unclear. For example, the description of services included such languages as services can be provided and as needed. Okay. Now, that's a problem we see frequently outside the COVID context, where the IEP just does not clearly describe the services, and kind of the existence of the pandemic didn't change the requirement that an IEP needs to be describing the services in a clear fashion so that the IEP can be implemented and that the parent can understand what the district's commitment of resources is. So here, the IEP team was talking about the students' need for in-person services, and because of the way the district had set up virtual services in the situation that it was in at the beginning of the school year, it just kind of shifted all that over to be, the IEP to match the district's predetermined schedule. That's not appropriate. All IEP teams' decisions need to be based on the individual disability-related needs of the student, and it needs to reflect that. Not the students, not the school schedule. It needs to reflect what the student needs. Okay. In 20058, we had this issue of contingency plans, and this the contingency plan came out of a recommendation we made coming out of that first period of statewide school closures, because at that point it was pretty clear that the pandemic wasn't going to end soon, and we knew that schools may need to be closed for shorter or longer periods of time during the 2021 school year. So we recommended that IEP teams develop contingency plans for students. So the IEP would clearly describe what FAPE looked like in the situation where the school was operating in a normal fashion. And then as an alternative, the contingency plan would be there, all right, in the event that school has to close for 10 days so we can quarantine or disinfect or whatever it happens to be. This is what the IEP would look like in this situation. So in this case, the district included 3 contingency plans in the student's IEP based on the 3 learning options that had been discussed at an IEP team meeting. The IEP team's intention was to implement the contingency plan based on the option that the student's parent chose, right? And that was the problem there, because again, the IEP needs to reflect the district's commitment, and just kind of leaving it in those terms of parent's choice, it was not clear that the IEP team was thinking about the student's individual needs. And again, this was a problem of describing accurately what the contingency plan was and when it would exactly be implemented. So we had to find that didn't meet the requirements.
So Paul, before you move on, I do have a question on IEP paperwork. Would you like to take that now?
Sure, that'd be fine.
Okay, it says, what do you do when an IEP paperwork is not provided to the parent at the end of an IEP meeting, and instead the paperwork is provided days or weeks afterward, and the content is changed from what is discussed at the meeting?
Okay. So a parent is entitled to a copy of the IEP prior to its implementation. There's no requirement that the parent have the copy of the IEP when they leave the IEPT meeting. Okay, so as long as the parent gets a copy of that IEP prior to when it's implemented, the legal requirements are met. Now, if the parent doesn't get the copy of the IEP until after it's been implemented, and usually there's the implementation date on the IEP. Let's say the IEP is going to be implemented next Monday, and the IEP doesn't get to the parent until 2 weeks later. That's a problem. And again, that something you want to talk to the district about. If it's an issue that's potentially could be an IDEA complaint. I lost track, Bonnie. What was the second part of that question?
That some of the information was changed from the initial meeting.
Right. So if you think that the IEP does not adequately reflect what the discussion was at the IEPT meeting, you can ask that the district change the IEP to reflect what was discussed, or you could request that the IEPT meet again so that you can discuss those particular issues and make sure that they're documented appropriately in the IEP.
Okay, thank you. I will have other questions, but we'll move on, and then we'll bring up some of those as we go along afterward, okay?
All right, very good.
Thank you.
Okay. 20061, again, a situation where the circumstances of COVID-19 resulted in an IEE being delayed. This involved a student who had been expelled since the spring of 2019 and was having difficulty being successful in the alternative setting that was, specified by the IEP team following the expulsion. The IEP team actually appropriately met to discuss the student's behavior issues. They conducted a functional behavioral assessment and developed a behavior intervention plan for the student. And they made modifications to the services and placement for the student, including more time in the regular education environment. But at the time of the meeting, there had been an independent educational evaluation, or IEE, requested. But the IEP team didn't come back together to discuss the results of that IEE until about 6 months after, or 6 or 8 months after it had been completed. And we found that the COVID-19 circumstances were not enough to justify that amount of delay, that the IEE result should have been considered by the IEP team almost immediately. A little side issue I'd like to highlight on this, which is something we want to remind people of. When a student has been expelled, the IDEA regulations give them a right to continue to receive FAPE, though in a different location. And FAPE in that situation means both progress in the regular education curriculum as well as towards their IEP goals. Sometimes IEP teams get too focused on just the IEP goals and the services that are being provided as FAPE, but it does include regular education. And in fact, in this complaint, the IEP team was appropriately considering that. It was just this IEE delay that caused the problem. 20062, evaluation not properly conducted when the eligibility determination was delayed for 6 months. Consent to evaluate this student was received at the end of January 2020, just a little bit before we had the statewide closures, but the evaluation was not completed until October 2020. And our decision here was that, even though we were in that period of statewide closure from March through June, of 2020, the district should have considered the possibility of doing a virtual evaluation activities during that period of school closure, and certainly they should have resumed the evaluation activities as soon as the closure order had expired in July of 2020. So during that time period, evaluations still needed to go forward if at all possible, and certainly once the statewide closure was lifted, the evaluation should have proceeded immediately. Right. 21024 and 21007 are similar. One of these cases took place during the state mandated closure when all instruction was virtual, and the other took place during the 2021 school year when the district was operating on a hybrid schedule. In other words, they were offering some in-person and some virtual instruction during that time period. In both places, the student exhibited extended periods of absence from their virtual instruction. And in both cases, the department determined that the IEP team failed to convene to consider the effect of the student's absence and whether the IEP should be changed, additional services provided to address the student's absence if it was related to the student's disability-related needs. Again, in providing FAPE, a district has an obligation to monitor these types of things. And if the IEP isn't working, then the IEP team needs to meet to discuss what changes need to be made to ensure that the student continues to receive services and have their FAPE needs met.
So Paul,
Yep.
Paul, let me just interrupt here because I think this is part of a similar discussion. The question is, if a student is quarantined for 10 days, is the intention that schools should implement the contingency plan on day 1 of quarantine?
Well, that kind of depends on what the contingency plan says. So if there's a contingency plan ready to go, and the the contingency plan talks about a situation where the student is quarantined, then yes. There is kind of a general rule that absences less than 14 calendar days can just be treated as an absence, even though it may be quarantine or the student might actually have COVID, something like that, and that the IEP considerations don't kind of come into play until after that 14-day period. But certainly if there is a contingency plan in place, it talks about it being implemented when the student needs to be in quarantine, then yes, we would expect that implementation to occur on the first day of the quarantine.
Thank you.
Right. 2021. This is a kind of an interesting one. I say interesting in quotes. If you could see me, you would see me making the air quotes, right? During the 2021 school year, the district offered parents in general in the school district 3 choices: in-person, virtual, or hybrid instruction. The parents made their choice, as all parents in the district did, whether they were parents of students with disabilities or students without disabilities, and they elected the virtual option due to their concerns about ongoing health concerns for the student. Okay? The IEP developed for the student stated that due to the pandemic, the student receives their specialized instruction from mom, and that's in quotes, and then went on to explain how mom was told what to do and how she would report progress and results to the school, right? That's just not permitted, right? COVID, no COVID, specially designed instruction has to be provided at no cost to the parent by an appropriately licensed special education teacher. And the IEP team can't put that responsibility off onto the parent, even though the parent had opted for that virtual setting. The district needed to figure out how to make sure that instruction was being provided by an appropriately licensed educator. Now, this was a difficult situation, no question, because not only did the parent say they felt the student should receive virtual instruction, the parent also said, and I can't have any outside staff coming to our home to assist our child because of these health concerns. But that doesn't let the district off the hook from having the IEP team figure out how those services are going to be provided by appropriately licensed staff. All right, so that's sort of it for the COVID-related cases, and I think the big message there, right, is particularly now, since last summer and on through this previous school year and on into the current school year, the general expectation is that FAPE be provided, and that no matter what environment the student is receiving their education in, that the IEP be appropriately tailored and specific so that it can be implemented in that environment and that it can provide FAPE for the student. The next area I want to talk about is manifestation determinations. Just a reminder about manifestation determinations, okay? The manifestation determination is a due process right, okay? And it's in place so that we avoid depriving students of their access to the regular education environment and their educational services because of their disability. It's sort of a basic non-discrimination idea concept that we shouldn't punish students for their disability, because if it's related to their disability, they might not be able to self-control that behavior, which is causing the problem in the first place. Okay. Manifestation determinations are required only when there has been a disciplinary change of placement. In other words, the student has been removed from school because they have violated a school rule. And that disciplinary change of placement, by definition, only occurs if the student has been removed for more than 10 consecutive days. And in Wisconsin, because of our statewide disciplinary school discipline and expulsion suspension laws, that's only a situation where a student is being expelled, or they've been removed for more than 10 cumulative days, and those removals look like a pattern. The behavior that led to those removals is the same, and things like that, okay? So that's the only reason we're legally required to do a manifestation determination, is in those two circumstances, okay? In complaint 20027, the IEP team was, what I think, making a good faith effort to address students' behavior-related needs. The student had some pretty significant behavior issues while at school, okay? And at the point that the IEP team met to discuss these issues, expulsion was an option that was on the table with school administration, but they hadn't notified the parent that they were intending to expel the student. Okay. So really there was no manifestation determination required at that point, because the district wasn't moving forward with that expulsion and the student hadn't been removed more than 10 cumulative days during that school year. So the IEP team met and they actually did a manifestation determination. And the first go around, they determined that the behavior was not a manifestation of the student's disability, but they thought maybe some more information would be needed in order to make that determination appropriately. So they met again a few weeks later and did the manifestation determination again, and at that point determined that the behavior was a manifestation of the student's disability. Okay. Now, the problem as we looked at this complaint was that that manifestation determination got all mixed up in the discussion about the student's disability-related needs and whether a change in placement was appropriate. And it just it confused the issue so much that we felt that an IDEA violation had taken place there. So it's important, I think, to remember that when manifestation determinations are done, they're only done when they're necessary. And if they take place when they're not necessary, it can get in the way of the work that the IEP team has to do to really consider the students' behavior-related needs and what services and specially designed instruction they might need to address those. In 2014, again, the student was removed only 4 cumulative days during the school year, so no manifestation determination was required. Like in 2027, the district went ahead and conducted one anyways. The district found the manifestation, found it to be, the team found it to be a manifestation of the student's disability, but then the district went ahead and altered the student's placement by shortening the school day rather than returning the student to the original placement as required by the manifestation determination rules. In other words, we've gone through that process and we've determined that your behavior was a manifestation of your disability. We can't, again, remove you from that placement because that would be removing you from the placement because of your disability, which is what the whole manifestation determination process is designed to prevent. So here, this kind of illustrates this point, and this has been a long-term position of the department, is that even when a school district does a manifestation that they don't legally have to do, they still need to abide by the results of that manifestation determination. So not required here, they did one, and that because the result of the determination was that it was a manifestation of the student's disability, they were not allowed to change the student's placement, and the student should have been returned to their placement prior to the manifestation determination. Okay. Moving on from manifestation determinations, talking about shortened days. Shortened days is an issue that we're seeing appear more frequently in IDEA complaints that we receive here at the department. Shortened day started out as a concept for students who didn't have the physical stamina to be at school for the full day. A lot of IEP teams are now considering, behavioral issues as sort of related to physical stamina. Students' behavior, may not permit the student to, participate in the full school day, and that then results in the IEP team making a shortened day determination for the student. The 2014, which is the case we just talked about, also involved a shortened day issue. And this bullet point here sort of illustrates the department's requirements whenever there's a shortened day for whatever reason. Okay. And in this case, the IEP didn't include this, but the student's IEP has to include an explanation of why the student's disability-related needs require a shortened day. There needs to be a plan for the student's return to school for a full day. And before deciding to shorten a student's day, the IEP team must consider if there are other ways to meet the student's needs. So those are kind of the 3 basic requirements that we need to see in an IEP, documenting the IEP team's discussion of this before we get to an appropriately shortened day. And in this case, that wasn't there. Right. 2018, the student had an IEP developed in late 2019. The team indicated the student needed a shortened day by noting that the student had transitioned from a hospital setting to homebound instruction, and shortened day would assist the student in transitioning to the neighborhood school. However, the team also included as part of the rationale for shortening the student's school day the fact that the student's behavior affected the learning of others. And that particular criteria that the IEP team identified and put it in the student's IEP was not an appropriate rationale for shortening the student's school day, because that was about the effect of the disability on others, and it did not address the central question of the student's own disability-related needs. And also here in this case, the team didn't include a specific plan to reconvene to review data on the student's progress to determine when it would be appropriate to increase the student's school day. And so that kind of left that open-ended and violated that, kind of basic tenet that shortened school days are a temporary solution. They're not a long-term solution. All right. In 21009, we actually found that, kind of what constitutes a shortened day and what doesn't constitute a shortened day. Here, a student had a schedule that began at 7:50 in the morning with one period of in-person learning, and then they were transported home to do their virtual learning for the rest of the school day, where they were participating virtually with their regular education peers in their regular education school. The day ended at 2:35 in the afternoon. Now, that school day from 7:50 in the morning to 2:35 in the afternoon was in alignment with the school day of all the other students at that school building, so that was not a problem. But the parent was questioning about that transportation time between, from the in-person learning first thing in the morning and the transportation time then before they got home and picked up with the remainder of their school day. Here we found that transportation time to be a reasonable and necessary part of the placement arrangement. The IEP team, had determined that the student was appropriate to have that in-person learning as well as the virtual learning, and that in itself did not result in a shortened day for the student, which would require, the shortened day discussion that we talked about earlier. In 21017, we had a situation where the district had a specialized program for students with more significant disabilities, and that program was in person. And the district looked at that program and said, well, we have a lot of mitigation measures that we need to do in that situation because many of the students are unable to wear masks. We need, extra time for cleaning and the like. So they just shortened the entire program by 1.5 hours a day. And that was shorter, again, than the typical school day for students in that district and at those grade levels. And the department in this decision said that's not an appropriate thing to do because you can't just shorten the day based on the program. If you're going to shorten a day, it has to be based on an individual student's needs, and the individual student's needs were not considered on a student by student basis in this case. It was just the result of the program, so we found that was not appropriate, not in compliance.
Paul, I have a couple of questions for you.
Okay.
And they have to do, well, one of them has to do specifically with the shortened day. When you speak about a plan addressing a student's return to a full day of school, what would that plan actually entail?
Yes, so the one thing it would entail would be a schedule of when the IEP team is going to meet to consider the student's current circumstances. So, it might be the IEP team will meet on a monthly basis until the student is back at full-time attendance. The other thing that the plan should specify is what data the team is going to collect and monitor to determine, how the student is making progress towards a full-time return. And that, of course, would vary from student to student depending on their needs and what the circumstances are. So you sort of have to establish some benchmarks that you're going to be looking at in that kind of enhanced schedule of meeting more frequently until you can get the student back up to full-time participation.
I have a couple of other questions. Are complainants entitled to receive a copy of the district's corrective action plan that was ordered as a result of the complaint?
Yes, if they want to request that from us, we will provide the corrective action plan for them.
Okay, thank you. And I do have another question. Do you want it now or do you want me to wait?
We can take it now.
Does the special education student have a right to expect that the necessary language and communication disabilities related needs are accommodated on the bus transportation as well as in a school building?
I think the general answer to that question is yes. Although what particular accommodations and services the student would require on the bus in order to benefit from that service, again, would be a case-by-case determination made by the IEP team.
Okay, and that's all I have right now. Thank you.
Okay, all right. A couple of issues on evaluations, 20006. Kind of maybe related a little bit to this question. The team did not adequately consider whether the determinant factor for the student's eligibility was the student's limited English proficiency, right? And this was actually, I believe the complaint was brought by a staff member who was concerned about how the district was conducting those types of evaluations. And it's just a reminder, right, that limited English proficiency is one of those exclusionary factors that need to be very carefully considered in the evaluation process. 2015, another reminder, which is something we've been saying for years, but cropped up in this complaint, right? So parent comes in for a parent-teacher conference. The district staff member and the parent discuss the student's current academic progress. The district staff member indicated the student could benefit from some additional practice in reading, which would increase the student's oral fluency, vocabulary, and reading comprehension. Based on classroom observations and informal assessments specific to reading, that staff person didn't have their own reason to believe that the student's academic performance was related to a disability. However, shortly after this parent-teacher conference, the parent contacted the district by phone and email to discuss the student's medical diagnosis of dyslexia and said she wanted to learn about special reading assistance for students with learning disabilities. The district responded and said, well, we can evaluate the student in the area of SLD, but the student had to participate in reading interventions prior to starting a special education evaluation. Staff members stated that the district intervention team would meet following a break to determine whether the student required additional support in oral fluency and comprehension. Parent said again, I'd like to ask for information on how to start an evaluation. And as you see on the slide, the parent didn't use the exact words special education evaluation. However, as we investigated that complaint, it was pretty clear to us that that's what the parent was asking for. And we found that the district did not respond appropriately to that parent's request by beginning the evaluation process. So this is a reminder that districts have an obligation to help parents who are asking about these issues understand their right to request a referral for evaluation and explain to them how to actually go about doing that. So even though the district probably had some reasonable reasons for believing the student would not qualify for special education under the IDEA rules. They still had an obligation to allow the parent access to that process as they're entitled to under state and federal special education law. Okay, one more issue on evaluation. We've had kind of a, I don't know what you call it this summer, and it's affecting particularly private school SLD evaluations. We had a complaint decision this summer in which we took a look at the SLD rule, specific learning disability rule, which was originally put into place back in 2013. And in the context of this complaint, we recognized that our previous guidance about using the discrepancy model for students who are parentally placed in a private school for SLD evaluations was not supportable by the law. So we've had to take down our guidance that instructed districts that the discrepancy model would be appropriate for those students. And we've had to, begun explaining to districts that they need to use the same model for SLD evaluations for private school students that they do for public school students. So that's caused some confusion. It's caused some concern amongst private school parents. It does not mean that parentally placed private school students cannot be found eligible under the SLD disability area. It just means that the district needs to use a different process to conduct that evaluation. So that's out there. In just a minute, I'm going to talk about some changes coming potentially in the rule that might address that situation. But for the moment, the districts are not allowed to use the discrepancy model for private school evaluations. 21006 has to do with ESY services. In this case, the student's IEP team determined that a student would need extended school year services. Okay. After they did that, the parent asked if the student could also be included in the district-operated community-based summer enrichment program. The district denied the request and explained that the student could not participate in both ESY and the community-based program. In a notice to the parents, the district said, students with disabilities in grade 8 through 11 are offered the opportunity to participate in a community-based enrichment program through the Recreation Department in place of extended school year. Your request to participate in ESY and the community-based enrichment program is denied. Okay. Can't do that. Can't exclude a student from one program or the other based on their need for special education services, in this case, extended school year services. It may be that, on an individualized basis, you could determine that the student could receive their services within the context of the enrichment program. It may be that on an individualized basis, the IEP team would determine that it would not be possible to provide the ESY services in that enrichment program. And that's okay because that would be an individualized determination by the IEP team. But it can't be just a district-wide policy that automatically students who receive ESY services cannot participate in the summer enrichment program. Okay, moving on from complaint decisions. This year has been sort of busy when it comes to state administrative code rule changes and the impairment criteria. We've had a few be adopted and go into effect. The first one created the category of eligibility called deaf-blind. That brings us into alignment with the federal requirements that went into effect on August 1st of this year. There were some revisions to the deaf and hard of hearing and blind and visually impaired criteria, also now in effect as of August 1st. There was again some effort to align that with federal requirements, as well as update some of the language so that it reflected the current use of language out there in the field. Changes to speech and language criteria for similar reasons also in effect on August 1st of 21. So if you want more detailed information about that, I really don't want to get into the weeds with you on that because we're kind of running out of time here. Just go to the special education team webpage, and you can search for deaf, blind, deaf or hard of hearing, speech and language, and there will be information on there on the details of those changes. We have similar revisions proposed for the emotional behavioral disability category, as well as the specific learning disabilities category. Both of those are still pending with the legislature. The legislature has some concerns about those, and we're working on ironing those out to their satisfaction so that the rule can go forward and be adopted. If you want more information about those, if you want to see the comments that the public has made and the DPI responses to those comments, you can visit the DPI's administrative rule homepage, where all of that information that has been created around the development of those rules is available for you to take a look at. Okay, real quick here, this issue of face coverings, and you've probably seen a great deal about this in the newspapers and other media about this. And this is kind of an intersection of non-discrimination law and IDEA, right? And figuring out what applies where is kind of difficult, because in some senses this is new, right? We've never lived through a pandemic before. Last one was way back at the beginning of the last century, and we've not had the opportunity for the courts to sort of iron out these issues for us, although they're in the process of doing that, right? So I think there are a couple of different things, right? One is, you've got a disability-related need, which results in the student being unable to wear a mask in situations where the school has a policy that requires wearing a mask. Okay, this was an issue that we confronted early on in the pandemic, and the guidance is basically, well, for sure, the IEP team needs to consider what the effect of the student's ability to comply with mask mandates is on FAPE, okay? And the IEP team is responsible for considering alternatives. If the student can't wear a mask, are there other types of devices that can stop the spread of COVID that would be appropriate? If there's nothing to be done, are there other precautions that staff can use, other students can use? Are there other placements that would be appropriate for students? New, right, is this issue which is now coming up, which is the disability-related need requires others around the student to wear masks. Okay, and there I think it's a little bit IDEA, and there's a little bit of non-discrimination law going on here, right? Certainly, I think an IEP team can think about, okay, does the what's the location of the services? Should staff who are working directly with the student be required to wear a mask? That's probably something IEP team should be thinking about. Can the IEP team under IDEA compel everybody in the school to wear a mask because the student has a disability-related need that requires that? That's the non-discrimination question, and that's the one that's not very clear yet, which is why you've seen, the ACLU has sued a couple of states over this issue, and they're kind of approaching that under an Americans with Disabilities Act analysis rather than IDEA, I think, because that's where it's more appropriate. So that's yet to be determined. I think there's legitimate arguments on both sides about how to approach that. and it's going to be settled. Finally, there's this, kind of the personal objections to wearing masks. Some people are asserting that they have religious First Amendment reasons for not being required to comply with the local mask mandate. Um, and that goes even kind of beyond non-discrimination law out there into First Amendment law, which is way beyond, what DPI does. But that's, again, something that will need to be worked out in the courts. So next slide is just all of the resources that we've developed on COVID-19 and special education. We're constantly updating these, so I really recommend that you visit our website. If you've got questions about this, many of your questions can be answered there. And finally, I'll just have my contact information here. I invite anybody who's listening, if you've got questions about these issues, give me a call. If I can't answer it, I can put you in touch with somebody who probably can. So with that, Bonnie, it looks like it's 1 o'clock and I've used up my whole hour.
Well, I do have just one or two quick questions. If you don't mind taking those before we end, we can extend for about 2 or 3 minutes if that's okay.
I can do that. Yep. Mm-hmm.
Okay, the first question is, are people actually looking to have that information about masks written into IEPs at this time?
We have had questions about that. Is that an appropriate thing to do? And as a matter of fact, I think we're going to officially answer that question this week, and it will go in the question and answer document. So that will be something to look for in the next couple of days here.
Okay, thank you for that. And the last question that we have is, where can the person find the proposed changes to SLD and EBD?
Mm-hmm. Yep, that's on that. It's linked on that slide where I talked about those issues. If you just go to the department's website and search in the search box for administrative rules, that will take you to the DPI webpage that has links to all of that information.
Well, thank you so very much, Paul. That ends our questions, and we really appreciate the information that you provided for us today. I know that I learned a lot, and I'm sure that others who have participated have as well. So thank you again. This will conclude our webinar for today, and we'd like to thank everyone for joining us. And we'd like to remind you that Wisconsin Facets has over 100 scheduled trainings and webinars, and that we would invite you to check out our website and register for any of the upcoming trainings that may be of interest to you. And also, please watch for the short evaluation that will be coming your way after the live presentation today. So again, thank you, Paul, and thank you everybody for participating. Be safe and have a good rest of your week. Bye-bye, everybody.